Hamilton Joseph. Don't do that.
Arun, I think you can perhaps welcome everybody. Hi, Mohan.
Yes. I'm just getting that live streaming.
It says live on YouTube.
Yeah. Can you see it now?
I can.
Okay, fantastic.
Hi.
Yes, I will.
This is the first large meeting that we are doing online. Hi, Leo. So, and Arun has been helping us, and so has Divakar to coordinate and put it together.
Yeah. So warm welcome to everyone.
Thank you.
Yeah, we will commence in a few minutes.
I hope Sujata is not going to be late.
Yeah. Is Sujata here yet? No.
Education.
നോട്ട് என்ன பார்க்க வேண்டாம் என்ன பார்க்க வேண்டாம் அவன் என்ன பார்க்க வேண்டாம்
Arun?
Yes. Good.
Can you make me co-host so I can share a couple of slides?
Yeah, sure.
Yeah. And also, if you can set your settings so that anyone who joins, as soon as they join, they are muted automatically.
Yeah, I think that setting is what I didn't
set
up.
I can quickly do it.
Sure.
Then the conversation will not be disturbed by anyone.
Yeah, even I didn't find that.
No, first you make me co-host. You click on my name and make me co-host.
I have a host option.
No, you're the host.
Yeah, there's no co-host option. The host option, then the recording, I won't have rights.
No. You can't make me co-host.
There's no co-host option. I think the co-host option is for a webinar. This is for a meeting.
Oh, I see. This is ending at 40 minutes, is it?
No, meeting license.
So how would I show? I can't show then the screen share.
No, I can allow multiple participants screen share. That's not a problem.
Okay, as long as that.
Yeah, co-host is for webinar options. Yeah, not for meetings. Yeah. So I'll just request.
And where is it live on?
No, it doesn't end in 40 minutes. Yeah. So yeah, that's just allowed. Multiple participants can share.
That's good. Okay.
Yes, please do that. YouTube.
Is it in your ears? Okay.
Yes, please do that.
Sit quiet.
Unmute your mic to do the welcome.
It's not through the. It's not through the.
I have muted all.
Please unmute Sujata.
Hello.
Hi, Sujata, in 1 minute.
Yeah.
Yeah.
Can you hear me, Tara?
Yes, yes.
Yeah. Okay.
Yeah, it's 5 p.m. So I think we should start. I request everybody else, other than the speaker, to keep their mics unmuted.
Good evening, everybody. I'm of Chennai chapter of INTAC. I welcome each of you, members and friends of INTAC, and all of you who've joined online today to be with us, and especially to our speakers of the evening, Mr. Leo Saldana of the Environment Support Group, and Mr. Surit Patsati, who has the dual distinction of being a lawyer and a journalist, and to Professor Arun Menon of IIT, who's been a great friend and support to INTAC, and who will moderate today's session. INTAC, the Indian National Trust for Art and Cultural Heritage, was formed 36 years ago as a non-profit organization. We at Chennai chapter, through various programs and initiatives, have been having different programs creating heritage awareness of our built heritage, our cultural heritage, intangible heritage, and of course, natural heritage, which is the focus of today's talk. And in the current circumstances, online platforms to meet seem to be the way to go. And we were happy to have a few weeks ago an online presentation by Steve Fernandez from the UK, who's an expert on injecting new life into heritage buildings. That was a program that we had jointly with IIT Madras. And today we are happy to have the first of our 4 programs for July, which will be on the forthcoming Thursdays. Every Thursday around this time, we will have a program for July. And today will be the first of the 4. May I request Arun Menon to please take over and introduce the speakers. Thank you.
Thank you, Sujata. I have the august responsibility of introducing the speakers of this evening's program. Leo Saldana is a full-time coordinator and trustee of Environment Support Group, ESG. He has gained wide-ranging experience in the areas of environmental law and policy, decentralization, urban planning, and a variety of human rights and development-related issues, working across these sectors for over 30 years. He's a keen campaigner on critical environmental and social justice issues and has guided several campaigns demanding evolution of progressive laws and effective action. He's creatively supported various distressed communities to secure justice through public interest litigations and advocacy efforts, arguing several public interest litigations as party in person. He's co-author of several books and reports, notable among which are Green Tapeism, a review of environmental impact assessment notification 2006, Tearing Through the Water Landscape, Evaluating the environmental and social consequences of POSCO project in Orissa, Forfeiting Our Commons, a case for protecting and conserving Chalakere's Amrit Mahal Kavals and livelihoods supporting biodiversity-rich and ecologically sensitive grassland ecosystems, Comprehensive Review Report of Environmental Decision-Making in Karnataka State. His papers and articles have appeared in many leading newspapers, journals, and magazines, including Oxford University Press Publications, India's Risks, Democratizing the Management of Threats to Environment, Health, and Values in 2014, and Living Rivers, Dying Rivers in 2015. Leo facilitates a variety of learning programs on environmental and social justice concerns for a wide range of audiences. Our second speaker, Surit Parthasarathy, is an advocate at the Madras High Court. With a first degree in law from National University of Juridical Sciences, Calcutta, with a graduate degree in journalism from Columbia University, New York. Surit's litigation practice is primarily focused on constitutional law and taxation. He's a regular contributor to the opinion pages, editorial pages of the Hindu newspaper, where he writes predominantly on the law. He's also published articles in a number of other dailies and magazines, including the Caravan magazine, the Open magazine, the Indian Express, and the websites of the New Yorker, the Atlantic, and the New York Times. Surit has also contributed chapters to two books, Dignity in the Legal and Political Philosophy of Ronald Dworkin, and Appointment of Judges to the Supreme Court of India, Transparency, Accountability, and Independence, both published by the Oxford University Press. A very warm welcome to our speakers today. Thank you.
Please ask Leo to
yes, Mr. Leo, you can share your screen and please commence your presentation, please. Thank you.
Yeah, so I guess everyone has seen this document, which is what has brought us all together this evening. This is the draft of the 2020 EIA notification proposed by Prakash Javadekar, the Minister for Environment and Forests. And he's doing this because this is what is now applicable. This is a collation of the EIA notification 2006 and all its circulars and clarifications and further clarifications on the clarifications, amendments and so on. I think about 150 of them. So basically what I'm saying is a document which starts like this, which is about 40 pages thick, will end up being 660 pages in no time. Because why I share this is because in 2006, we wrote this book in which we said the 2006 notification is terrible and it has to be withdrawn. And we deserve better. India deserves better. Now, having shown these three documents, I can also share this much that India deserves better because one of the founders of INTAC, Mr. N.D. Jayal, was an architect of the EIA process in India. And for that, I must share the screen and let me do that. Sorry, just trying to see amongst the multiple pages, which one is the one I chose. And that's a PDF, and I'm not able to see it. I guess the PDFs cannot be shared on this platform because it's not showing up.
They can be. They can be. I think that's not a problem. You should be able to share any screen.
I agree. Okay, maybe yes. Let me try again. Okay. You're right. Thank you.
Yeah.
So I want to start by showing you this report. Okay, this report, which was typed and published in 1980 by the Department of Science and Technology. I think at that time, Mr. Jayal was the secretary of the department. N.D. Tiwari, later on infamous N.D. Tiwari, was the chairperson and also the deputy chairman of the Planning Commission. And Indira Gandhi basically said, development is happening all across the country. And see, the idea of development itself was uncontestable at that time, right? So that was everything. India had to develop. How else can you govern this country, which is so populated and so diverse? And so Mr. Tiwari was asked as deputy chairman to constitute a committee. And that's a long title of it, Report of the Committee for Recommending Legislative Measures and et cetera, for environmental protection. And after almost a year of work, they submitted this report. Now, if you read this report, which I do every time I am sort of confused about where our government is, you see this report is written by a certain quality of concern which is totally missing in the ministry today. Not just in terms of language, but in terms of approach, in terms of its methodology, in the way in which it contextualizes what environment is, how it relates with the then available information of the crisis, environmental crisis. And they actually say in 1980, the country is rushing headlong into a massive catastrophic environmental crisis. And they talk about soil erosion, forest depletion. They talk about the fact that rivers are getting dirty. They talk about poverty being exacerbated by industrial pollution. They look at the farming crisis. And this was done not by sitting in Delhi. The committee traveled around, went and listened to people. And when they wanted more time, they went back and said, we need more time. And Mr. Tiwari went and told the Prime Minister, we need more time. We can't rush this. This is a very, very critical exercise. And so they got time and then finally wrote this report. In this at 2.31, I think, they talk about EIA. And let's understand where the EIA concept comes from. Okay, so basically for them, the idea of an environment impact assessment was not a ritual. They had seen the fact that there were a variety of damaging consequences to development. They had seen that the 1974 Act of Water Act had not really performed its due role. We still had not yet come to a stage where the Bhopal gas crime would take place. But they knew that things were bad. They also said air pollution was getting terrible, and so we needed a new law for air pollution. And so this is the way in which they looked at noise, they looked at land pollution, and then finally they came to this. They said the unintended environmental impacts resulting from execution of development projects, various development projects they list out, and mining operations, land subsidence. Where do we talk even about land subsidence now? Like Chennai is sinking, but does anyone even care? Scarring of large tracts of land. Now, scarring of large tracts, there's an aesthetic quality here. It's not just, development means something comes up where there was a forest. It's also, you don't do anything, but you don't take care of landforms, landscapes, and you destroy the aesthetic quality of it. Indiscriminate discharge of waste. And they're saying that there are other serious and more insidious consequences for human health arising through poorly planned developmental activities. Now, you see the pandemic and the scale at which the pandemic is spreading and intensifying is largely a consequence of poorly planned development in urban areas. We are too thickly populated. There's simply no open space for us to spread out when we have a virus which is hitting us like this. Now, they obviously probably did not imagine, but look at the next sentence. In particular, there is a whole range of tropical communicable diseases such as malaria, filariasis, dengue, guinea worm, that are becoming more widespread because of the creation of favorable environmental conditions for the pathogens. The majority of the breeding places of these disease vectors are created by man in the form of stagnant water bodies such as reservoirs, ranging from human lungs to ancient monuments. Human lungs, that is COVID, to ancient monuments when our lungs turn on ourselves, and ancient monuments when they're neglected and become a cesspool of all sorts of diseases. And so they argue that we need to conduct an environmental impact of development projects, and they bring up certain values. And basically their values are, it has to be an interdisciplinary approach. For such work is yet to be built to any significant extent. They admit that we just simply don't have an interdisciplinary approach to planning and development. And they say there is no statutory backing to ensure compliance. Regulation is critical to make sure that, whatever we want to organize, the material that we excavate and organize as useful material so that we can live in it, work in it, make money out of it, happens in a certain way that it doesn't destroy the chances for anybody else, especially for the future generations, right? And there is no mechanism for systematic monitoring to see whether environmental safeguards are there. They go on to suggest that the environmental law is required, and subsequently in 1986 we get the law. Now, the reason I bring us back to 1980 is because if there was real concern for this country, if we go back to 1980, you'll find language without the people's support and involvement at the field level. It will be difficult to ensure environmental considerations become an integral and important part of the process of project formulation and implementation. Now, you take any of the other languages that have come subsequently, except perhaps the 1988 forest policy, you don't even find it in the environmental policy of 2005 or 6. Instead, if you take this language, this is a report, a critique we wrote on this report. I don't know if you can see this. Am I sharing my screen still? Can you see this report I'm showing?
Yes, sir.
Yes.
Yes.
So this is the report that TSR Subramaniam, is no more, but this was the first major reform that Prime Minister Narendra Modi undertook. He asked Subramaniam to go out and look at 6 environmental laws and find everything that's problematic in them and come back in 2 months' time with suggestions on how to change those laws so that business can progress, right? There was no hiding the fact that this administration was intent on demolishing environmental forest protection, laws relating to town and country planning, none of that. I mean, there's no pretense even.
Mr. Saldana, sorry to disturb, request to speak a little louder from few participants.
So anyway, Subramaniam produced the report in 3 months' time, and we had serious problems with it, and this critique is what my colleague Bhargavi and I wrote, in which we essentially argued that, if you go ahead with what Subramaniam presents, and it was very simple, his idea. He said the principle of utmost good faith should prevail. And what does that imply? That we must trust industry, commerce, infrastructure developers to do right. We should have the utmost good faith in their actions and thus not be obstructionist. And then India's GDP would rise. India would become part of the G8, perhaps displace Russia, who knows, displace even China, because that was the kind of imagination in 2015, right? Now, we protested this report, and obviously it was not implemented officially. But if you take a look at the EIA notification 2020, it is based on the principle of utmost good faith. What it essentially means is polluters must be trusted to clean up their act. Now, if that were true, all the disasters that are unfolding in the last month as industries are opening would not have happened. Because if they were really, really keen, I mean, one can blame the Prime Minister for shutting down the country in 4 hours. Incredible that, even thought it was the right thing to do. So industries rushed and shut down. But the fact is simple, that if regulatory systems had actually worked, they would have instructed each and every industry that you cannot shut down rapidly. You need to phase down, you should protect your chemicals, and when you want to open them up again, once the lockdown is gone, you must do it there are manuals, you follow the manuals, you make sure, I mean, chemistry doesn't play politics. It behaves in the way it is, material is designed, right? So you can see that the Neyveli Lignite Corporation, twice it blew up the boilers. What happened in Assam, the oil wells blowing up. I mean, at least 30, 40 people have died. We don't know how many more in small and medium scale industries. Now, despite that, what it really says is our environmental regulatory systems have collapsed. Because if they were working, none of this should have happened. Nowhere else in the world this has happened. The whole world went into lockdown. But when they opened up, their industries didn't blow up, their thermal power plants didn't blow up, their gas cylinders didn't just explode. Why is it happening in India, right? So this is indicative of the precipitous drop in environmental governance rigor. Now, this is exactly what we predicted would happen when in this book, Green Tapeism, you can download it, it's there on our website. Basically what we said was very simple. We looked at the EIA notification 2006 and we said this is not a notification written to build environmental quality, aesthetic quality of this country. This is a notification which has been written to please industry and make sure industrialists find India a great destination for investment. So, for instance, the objectives of the EIA notification were to incorporate necessary environmental safeguards and planning at the planning stage, involve the term stakeholders. I don't like it. It's the World Bank jargon, which basically says only those who have stakes can participate. What of those who are concerned? Identify development projects based on impact potential instead of investment. This was the objective with which the EIA notification 2006 was conceived. But what it ended up doing was weak review of environmental and social impacts, reduced involvement of local governance bodies, and also the wide public, and a preferred status to investment or environmental and social concerns. In other words, already the deterioration had taken place in UPA 1. Now UPA 1 was credited with Right to Information Act, Forest Rights Act, but on the other side, there was this man called Pradipta Ghosh, who was then secretary, who was, part of a committee which had been set up during Vajpayee's time as Prime Minister, which was called the Govindarajan Committee on Investment Reforms. And Pradipta Ghosh, as a member of the committee, had worked to identify bottlenecks for investment. And he, along with Arun Shauri and Govindarajan, had presented a report to Vajpayee and said, the most significant bottlenecks to investment are environmental and forest clearance mechanisms, which are statutory. So the answer was dilute them. So we need more foreign direct investment, we need more private sector investment, we need more public sector expansion. All of that is possible provided that effectively meant open up coal mining areas, destroy forests, pollute rivers, destroy coastal areas, I mean put up whatever you want everywhere, weaken land use control laws, and it goes on and on. The Govindarajan Committee report is almost 1,500 pages, right? Now, we have all sorts of treaties. I mean, the Rio Declaration is very clear in terms of what the objectives of environmental impact assessment are. But, there have been voices, and the Supreme Court has been one clear voice. And in the Supreme Court is this great man who came from Kerala and went on to become a judge of the Supreme Court, Justice Krishna Iyer. And he said, if life is dear, environment too is dear, and environmental justice is thus a foremost constitutional value. And he went on to say that the constitutional provisions have to be read broadly with the right to life and dignity as cornerstone of constitutional guarantee, and procedural law is the instrument of substantive provisions. Now, this is procedural law. The environment impact assessment is a mere notification. So one of the arguments we make in this book is that when you have a notification, it is malleable by the executive. It doesn't have to go to parliament. Now, this EIA notification 2020 is not going to parliament. Now, there are some friends who say that if it went to parliament also it would get passed. There is no rigor in the parliament of today because it's so populist and populist and so on. But here's my argument. How can you allow a subordinate legislation to decide fundamental rights? Because the EI notification allows the administration and investment lobbies to make and shape decisions which affect the lives and livelihoods of millions of people across India. It can decide how to turn a river, dam a river, open up a mine, shut down a coastal area to fishing communities and open it up for Adani, for instance, open up a huge, humongous steel plant in Orissa for POSCO. You can basically do anything. Now, while all this was happening, there have been some states which actually are quite keen on protecting their own environments. And one such state was actually Karnataka. And here in Karnataka, we were, my colleague Bhargav and I co-led a project with the State Environment Department. And this is the report we published. You can download it. And because we wrote everything honestly, they banned the report. We published it in 2014. We studied 550 projects in Karnataka, which had been cleared between 2002 and 2012. Now, you see, between 1980 and 1994, when the EIA notification came, 1980 is when Tiwari committee submitted the report. 1994 is when the EIA notification was first brought into effect, and then various versions. There was no impact assessment. But the Tiwari committee had allowed states to create their own mechanism, and Karnataka actually did a pretty good job of developing a mechanism called the State Environment Clearance Committee. Now, this committee had functioned for 10 years and cleared all sorts of projects, and that order had been amended. And then when the EIA notification came, they said, do we need to continue? Now, we were asked to examine that question, and we did, and we studied 550 projects, and we found special economic zones were cleared under that facility. When you look at the EIA notification 2006, there is no scope for clearing special economic zones. They are out of bounds. Defense is out of bounds. Metro is out of bounds. Biotech is out of bounds. Agri-biotech sector is out of bounds. I mean, these are massive investments, but they're not covered under the EIA notification, right? So there is this type of construct, huge gap, which Karnataka had attended to. And when we really sincerely worked to improve the State Environment Clearance Committee and produce this report, they found it so problematic that they actually, like the principal secretary then was one Mr. Saif Salam, in a meeting he said, I'm going to send your report in an elliptical orbit like that of a comet. So it will never come back in several lifetimes. So what we could only do was share it publicly so that it kind of helps anyone who is interested in knowing that there is a very, very serious threat. And that serious threat today is, I'll just show you what Karnataka is doing. This is from 3 days ago. All you need is one clearance. You just apply online, you self-certify, that is the principle of utmost good faith, comments and acknowledgement certificate will be given, and then you go to whatever you want. So I think to sum up, I can only say that we are probably in the worst period when everything we hope for and would be built on to improve the regulatory systems, land use policies, and create a better country is being destroyed right in front of our eyes. So it's a big, big wake-up call, and we must immediately act on it. Thank you.
Thank you. Thank you. Surit Parthasarathi, do you have a screen to be shared, or?
No, I don't have a screen to be shared.
Fine. Thank you. Please go ahead.
Sure. Yeah, so very good evening to everybody, and a big thank you to Ms. Tara Murali and the Intax Chennai chapter for this invitation. I think it's a great pleasure and a privilege to be speaking to all of you on a subject that is really of substantial importance. We've already heard Leo Saldana's comprehensive and wide-reaching talk, and I think it ought to be clear to all of us by now why the draft EIA notification is a problem and why there needs to be greater resistance against the notification. Given Leo's sort of coverage of the process of EIA itself to a certain extent, what I'll try and do over the course of the next 15-20 minutes is to place all of this in the context of the larger rule of law. Because, as we've already seen, the notification has a bearing on a slew of different areas, obviously from the environment as it is, but also on climate change, global warming, on the preservation of our cultural heritage of buildings and items of value and so forth. So what I'll do, therefore, is to lay a little bit of a foundation and try and give us a bit of context on how this notification impinges on our rights. I mean, we all know that we are a country that is governed by the Constitution, that the Constitution establishes a certain structure of governance, that it divides responsibilities between different agencies, it separates power, it tells us which government has the authority to make what kinds of laws and so on. But it also critically has two sets of separate stipulations in parts 3 and 4 of the text. I know some of us are familiar with some of this, but I thought it was important to go over this just to kind of try and explicate why this draft notification is a potential problem. Now, part 3 of the Constitution deals with fundamental rights. So these are, for example, the right to equality that is guaranteed in Article 14, the right to freedom of speech, the right to freedom of assembly, the right to life and personal liberty under Article 21, the right to freedom of religion, and so forth. Now, these rights are specifically enforceable. So, for example, if the government is to make a law tomorrow and say that no free press is permissible, or that nobody can publish items of news, etc., then you can go to a court of law, you can go to the Supreme Court, or you could go to one of the high courts and have such a law struck down. So these fundamental rights are enforceable. The chapter on fundamental rights also defines what a law is. I think there's some feedback that I'm getting which is kind of echoing mine. So if I can just request others to put their microphones on mute if it's not a problem.
It's all on mute, so I just verified that.
I think that was not, yeah, anyway, yeah, thanks, thank you. So it defines what a law is, it also defines what a state is, and it tells us that the state cannot, through its acts or omissions, violate a fundamental right. So when the state does that, then the courts are duty bound to intervene either by striking down these actions or by demanding that the state act in a certain way by issuing what we lawyers describe as a writ of mandamus. Now, all of this is important because I'm going to try and tell you where the environment and where the nation and our culture's sort of heritage fits into all of this. But before we get into that, let's just briefly look at the next part, that is part 4. Now, this part contains a set of directive principles of state policy. It's meant to enjoin the state to do certain things. So it tells the state what it must strive to do, what kinds of laws it must endeavor to make. But these directive principles are not enforceable in a court of law. So, for example, the directive principles say that the state shall take steps to ensure that citizens, that is, men and women, equally have the right to an adequate means of livelihood, that the state shall try and create a uniform civil code, that it shall try and ensure equal pay for equal work, that it shall try and promote cottage industries. And there's a long list of these. And we'll certainly come to some of those soon. But these directive principles are not enforceable. So you can't go to a court and say that the state hasn't enforced a uniform civil code, that it hasn't helped promote cottage industries, because these principles are important. And the Supreme Court has shown us why these principles are important in sort of furthering the basic credo and aims of our Constitution. But you can't go to a court of law to enforce them. Now, this is especially important from the point of view of the environment. Because when we look at the environment and its relationship to the Constitution, you'll see that there are principles that are found both in parts 3 and 4. But the development of the law on this, that is in terms of trying to glean principles both from parts 3 and 4, has really only happened over the past 3 decades or so. And this development of a right to environment, so to speak, has had 2 different kinds of rationales to it. One has been a development of a substantive right to environment, and the other a procedural right to environment. I mean, Leo mentioned how the EIAs fit into the procedural aspect. Out a little bit more. Now, on the substantive basis, the most common link that is drawn in terms of trying to provide for a right to environment is drawn with Article 21 of the Constitution. That is the guarantee of a right to life and personal liberty. Because it is believed that the right to life includes a right to live with dignity, which in turn includes a right to an environment that is clean, pure, and free of all contamination. So, but this expansion of Article 21, which sort of in its literal terms speaks about the guarantee of a right to life and personal liberty, to sort of include these other rights, including a right to clean air and a right to a healthy environment and so forth, this hasn't been entirely non-controversial. because its sort of expansion is also coterminous with the growth of the PIL movement, which has again been far from contentious. And there are deep structural problems that have emanated out of this. But again, I sort of want to flag this off and we can come to it later. The directive principles have also made a difference, and in particular, Articles 47 and 48A. And although I would argue that 49 is also important, especially from the perspective with which we're approaching the subject today. Now, Article 47 says that the state shall regard the raising of the level of nutrition and the standard of living of the people and the improvement of public health as one of its primary duties. Article 48 says that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. Now, these are really the only explicit mentions of the environment that is made in the Constitution, and 48A was introduced by way of an amendment in 1976. 49 is also important because it says that it shall be the obligation of the state to protect every monument or place or object of artistic or historic interest, which is declared to be of national importance, and prevent those buildings or monuments from spoliation, disfigurement, etc. But largely on a reading of Articles 47 and 48A, the Supreme Court has held that the state has a duty to secure to all of us a clean environment. Now, as I said earlier, these are not enforceable mandates, but what the court has done is to say that our right to life includes within it a right to clean and healthy air and a clean environment. So that therefore includes a concomitant duty and places a concomitant duty, a positive duty on the state to ensure this. So this has led to the development of a whole jurisprudence sort of that didn't really exist all that long ago. I mean, we've heard some of this from Leo, but the bourgeoising really happened across the world, starting from the Stockholm Declaration in 1972, and the enactment in India, starting with the Water Act in the 70s, on to the Air Act in the early 1980s, and then ultimately with the Environment Protection Act of 1986, which was, of course, enacted on the back of the Bhopal gas tragedy. But what I'm really getting at is this, that a reading of constitutional rights as a benchmark for an environmental jurisprudence has also seen a concomitant development of a set of core principles. Principles such as sustainable development, the principle of polluter pays, the precautionary principle, and the idea of a public trust doctrine. I'll touch on these briefly when we look a little more closely at the draft EIA notification. But what I want to sort of emphasize here is that these are the substantive sort of rights that have been created. Some of these have been fashioned by the court, but they've been kind of read into this larger guarantee that is contained in Article 21. Now, while these are extensions of substantive principles, it's not to say that any development which happens, that is that there are not other procedural rights which are equally important. Now, and these are just as critical as Leo mentioned. So for example, if you look at the procedural rights that are at stake here, you'll have rights such as the right to access justice, the right to access information, the right to participate in the decision-making process, and so forth. So what these procedural rights do, and these are as much a part of Article 21, at least in sort of the kind of interpretation that the Supreme Court has given it, is to really give meaning to the substantive rights. So for example, if we didn't know that the government was planning, let's say, a pipeline through one of our forests, which will likely destroy the local ecology, if we didn't actually know this information, or if we had no means to secure this information, then the substantive right is effectively rendered meaningless. So these procedural rights, the right to know, the right to access information, and so forth, are just as critical. And you saw their first enunciation in the Rio Declaration of 1992. I'm not really going to get into that too much here. But what you see is that the Rio Declaration spells out a set of principles such as the right to access judicial and administrative proceedings by way of redress and remedy, the right to access information on hazardous materials, the right to participate in the decision-making process. And all of this has now been written into our laws effectively through sort of judicial construal and interpretation. Now, this therefore is the broad framework in which we are operating. So the question is, where does the environmental impact assessment come within this framework? Now, across the world, EIAs were largely introduced as a legal requirement in the 1960s to begin with, and India lagged behind substantially in this regard, because the idea behind an EIA, at least as it was introduced in America, was to secure a technical evaluation of a project, of anything that involved human action, and to get a report on precisely how this might impinge on the environment. But if you look at the sort of source of the EIAs itself, it was never with the intention actually of preserving the environment or sort of reducing the damage to the environment necessarily, or it never saw the intrinsic worth in the environment. Just because there was this movement for environmental rights that was happening, the core aim was still development. It was still sort of a movement towards the neoliberal economy that we have today. But the EIAs were introduced as a way to kind of get over this, right? To provide a mechanism that can ensure that these projects are cleared without sort of scuppering them. Now, in India, under the Environmental Protection Act of 1986, India initially did not notify any EIA norms. And it first notified EIA norms in 1994. And this sort of set in place a legal framework, again, as I said, for regulating activities that pollute natural resources in any manner, but ultimately to give go-aheads to projects. So every developmental project of a certain size was required to go through the EIA process for obtaining a prior environmental clearance ever since the notification in 1994. Now, there's some history. We don't need to really get into that in terms of prior to 1994, there were some projects, especially from river valley projects, which required environmental clearances. But by and large, the 1994 notification was the first real effort at codifying norms for providing for environmental impact assessment. Now, in 94, when the government notified these sort of notification under the 1986 Act, what you'll see is that the notification made it mandatory to obtain an environmental clearance for setting up new projects or expanding or modernizing any activity which was listed. I mean, these various kinds of projects were listed in a schedule in that notification. And now that schedule contained 29 categories. These included things like industries, mining, thermal power plants, river valley projects, ports, harbors, airports, etc. And the notification also led to the establishment of an impact assessment agency, which was effectively the Ministry for Environmental Forests itself. But the 94 notification was lacking in very many different regards. So there were a number of different amendments that were made to it. There were amendments in 97, in 2002, 2003, and so on and so forth. So it's, I think, quite safe to say that while it might have been better than having no EIAs conducted, the 94 regime was broadly a gross failure. It simply didn't take into account people's opinion. The Tista project in Sikkim, for example, is a classic example. There was intense and strong resistance from local communities there, but environmental clearance was still granted. Now, this was challenged before the National Environmental Appellate Authority, which was set up to review these ECs, but again, that came to nothing. Now, there's an excellent study that was conducted by Kanchi Kohli and Manju Menon, which documents the failings of the 94 notification. It speaks of how there was a complete exclusion of environmentally disruptive activities from the EIA process, how the quality of the EIA reports was incredibly poor. There was ineffective to virtually no personal hearings. There was ineffective appellate oversight by this National Environmental Appellate Authority, which I spoke about. And the list really is endless because, what you also saw was the quality of the personnel on these expert committees. They again left a lot to be desired. So this 94 notification was ultimately replaced by another EIA notification, as Leo mentioned, in 2006. And at least the perceived objective of the 2006 notification was to address the limitations that were there in the 94 notification. Now, one major difference that you might notice between these notifications is the sort of attempt to decentralize the EIA process. Now, earlier, all projects which were under that schedule went to the central government for clearance. But under the 2006 notification, many projects had to get the clearance from the state government as well, depending on their size, capacity, area, etc. Now, the important thing is this 2006 notification introduced 4 stages for obtaining a prior environmental clearance. It spoke of a stage of screening where the state environmental sort of forum, the SCAC, it details screening of, and let me just sort of, before that, it also sort of divided various different projects into a category A and a category B, with category A projects requiring clearance from the Ministry of Environmental and Forests, while category B needed clearance from the State Environment Appraisal Committee, which is the SCAC. So the 4 stages broadly were: first is a stage of screening, which was to be conducted by the SCAC for all these category B projects. Then the second stage was a stage of scoping, which was to be done by the EAC or the SEAC by determining sort of a detailed terms of reference. And then there was a stage of public consultation, and then ultimately a stage of appraisal. But what you really found was that the 2006 notification was in many ways a retrograde step, because it scarcely took into account considerations of transparency. It tried to fast track the clearance process. There was some progress in areas such as RTI, which was independent of this, but it still didn't provide people with access to full reports. Public hearings were possibly the only real exception. And one of the best critiques of the 2006 notification that you might see is from Leo's book and from his report from 2007. And the other thing that you found with the 2006 notification, indeed, that we continue to find, is that the appellate and judicial oversight of this has been abysmal. And I think the higher judiciary is quite a bit to blame for this. It's shown really a quite extraordinary level of deference to the grant of an environmental clearance. I mean, if you're going to treat environmental rights as an extension of Article 21, we need what is known as substantive due process, because the Supreme Court has repeatedly affirmed this as a principle contained within Article 21, that it guarantees not merely a procedural due process, but also a substantive due process. But every time an EC is challenged in court, or even before the NGT today, and it then goes to court from there, once the court sees that it's been cleared by some sort of supposedly expert body, then it doesn't really go into the substance of this at all. One of the intentions behind the NGT was to sort of permit this, in order to allow a tribunal, a specialized tribunal, to look into the substantive faults possibly in an EC. But it's still, again, even the NGT has shown a similar deference. And the instances of this are infinite. You have the Narmada Dam project, the Mullaperiyar Dam, the increasing the height of the Mullaperiyar Dam, the case of the airport in Hyderabad, the international airport in Hyderabad, and power stations across the country. It's really an endless list where the court has shown a quite extraordinary degree of deference to environmental clearances that have been obtained through the 2006 notification. But where the court has stepped in is for violation of procedure. So when the EIA, for example, has not been done in accordance with the 2006 notification, when there's a hole in the procedure, let's say, then the courts have been keener to interfere and at least sort of ensure that those procedures are complied with. Now, when we look at this draft notification of 2020, which is this sort of draft that's being tried to push through, the deadline for submitting comments has been extended by the Delhi High Court. I think the Karnataka High Court is also sort of getting into it now, so there might be more time to respond to it. But if you look at this draft notification, you'll see that it now categorizes projects into three, into a category A, a category B1, and a category B2. And it says that this category A and B1 shall comprise of those projects which have to go through 6 stages, which is the stage of scoping, preparation of a draft EIA report, a public consultation, a preparation of a final EIA, and an appraisal and a grant or rejection of a prior EC. Category B2 has fewer requirements, and category sort of B2 has fewer requirements. But if you look at some of the problems in this sort of categorization and in the notification as a whole, and I'll sort of won't belabor on this too much because there are a number of problems with it, but I'll just sort of broadly mention 5 big problems with this EIA notification. One is a sweeping exception that is provided for projects. It places various different projects under category B2, and it exempts them altogether from the stages of screening, scoping, public consultation, and appraisal. For example, it proposes that all projects that are under this category of B2 will be directly dealt with by the regulatory authority without referring the same to the SEAC. And now what we also see is that some of the projects that were under category A in the 2006 notification are placed in category B2 under the 2020 notification. For example, inland waterways, elevated roadways, standalone flyovers, bridges, which are sort of more than 150,000 square meters in size, etc. For all of these, you don't really need an EC. I mean, for less than that, you don't need an EC, but if it's more than that, it's placed under B2, which again sort of effectively doesn't require clearance by the SCAC. All that it needs is it's placed before the regulatory authority. The second big problem is that the expert appraisal committee, on which so much sort of responsibility has been placed, what you find is that it's rather rudderless. The AAC is a part-time body. It's nominated by the regulatory authority, and its resources, if you kind of look into it, it's almost laughable. And without strengthening the EAC to kind of place the sort of responsibility that is placed on it is, I think, a deep danger. And you've seen how this expert appraisal committee has operated, especially over the course of this lockdown. Some of these meetings have lasted for 10 minutes and they've cleared projects through these virtual conferences by spending no more than 5 to 10 minutes on them. So if that's the kind of process that's going to be employed, then again, you'll see the kind of quality of the EAs that's being conducted. The third thing is the idea of an ex post facto clearance. And this, I think, is a really, really big problem because this should be a non-starter. The Supreme Court and the NGT has warned against this in the past, but what the 2020 notification essentially permits is for projects which have commenced operations without a prior environmental clearance to then get a post facto clearance from the appraisal committee. This, I think, defeats the entire idea of an EIA really. The fourth problem is that public hearings have been hugely diluted because, again, it expands the list of projects that do not require public consultation before receiving prior ECs. And finally, it dilutes scoping quite substantially. What it does is that it provides that proposals for grant over terms of reference will be referred to the appraisal committee by the regulatory authority within sort of 30 days from the date of the EC application. But it then places a condition that if this regulatory authority does not refer the matter within that 30 days, then the standard terms of reference will be issued to the project. So these are sort of 5 really big problems with this 2020 notification, and the list again is endless. The other problem is, and it's especially sort of relevant, I think, to people who are participating in the conference today, which is that it doesn't really mention heritage buildings and sites really. I mean, you've seen in the 2006 notification, there's been sort of some broad mention of how when buildings are or projects are put up within a certain distance from heritage sites or buildings, then that needs to be mentioned within the form that is filled up for securing the environmental clearance. But again, the 2020 notification sort of carries forward with that and doesn't really do much for heritage buildings and sites at all. And I think that's a really big concern because what we see is that environmental clearances and environmental consequences really have a trickle-down effect, right? A flood, for example, can just as much affect the natural environment as it can affect buildings, heritage structures. We've seen supposedly natural disasters wreak havoc. But we don't really want to ask these questions because, and this is something that's been repeatedly stated by many different scholars, because even the way the Supreme Court has seen things is to place this on a sliding scale where development comes first, the environment comes next, and then the rights of the poor come. So what we really need, I think, is a large scale sort of reimagination, as Leo mentioned, because it's all well to say that Article 21 guarantees a right to clean air and healthy environment, or that these directive principles enjoin the state to protect our environment. These are constitutional guarantees, no doubt. But unless these constitutional guarantees really find meaning through clearly legislated codes, where the environment is seen as a value unto itself, where the protection of the environment is not so much seen as sort of having some sort of instrumental effect in the sense that it might, perhaps aid in certain things, or it might have other instrumental factors to it, but rather seen as having intrinsic value. It's only then that we'll really see progress on this front. I mean, we need to see preservation of not only our natural heritage and culture, but also sort of the larger environment as a value unto itself, in that unless you place kind of special emphasis and importance in this, the objective really can't be to say that, look, we need these projects cleared, that we need development to happen. What's the easiest way to get rid of the environmental aspect to it, in the sense that ensure that these projects get clearance while at the same time sort of paying lip service to the environment? That cannot be the aim. The aim has to be to provide a code which will seriously engage with the potential of a project to damage the natural environment, and then thereafter from there sort of then see how we can ensure that our other development takes place. And I think across the world, I mean, in America, we've had talk of a Green New Deal. In the UK, again, there's been some sort of statutes, draft laws, legislation that have been proposed on these fronts. I think we need something similar in India as well, because it cannot be one or the other. I mean, this entire principle of sustainable development, and I'm not naming specific case law here, but if you look at the way the Supreme Court has looked into sustainable development, what you essentially see is that development trumps the environment. That cannot be sustainable development, right? We need a system where, while we preserve the environment, we'll also sort of create jobs and ensure that the nation grows. So it can't be that it's either one or the other. And the moment you have this sort of scenario of one or the other, you'll only see notifications of this kind which are being proposed and which are being notified, where the environment is really treated as a secondary concern. So we need to really sort of move to a culture where we see the environment as a primary concern along with those other concerns that the government values or that other people value. So it's only then I think that we'll really see sort of progress on this end. Thank you very much.
Thank you, Surit. So I think we can get on with the question and answer session. I have both for Leo Saldana and you a set of questions that have been coming in through the last hour. So I'm going to float the question and then let you know to whom this question is addressed. But in some cases, the question is not specifically addressed to one or the other. So you could respond as you feel appropriate. So the first question that I have here from Mr. Anantakrishnan Ranganathan is, well, when no accountability is enforced by the Supreme Court, as can be seen with the PIL on the Mangalore airport, in this context, how do we safeguard the environment? Through the court is the question.
I guess that's a question for me, because I had the privilege of working with Captain Ranganathan in about 10 years ago about the second runway for the Chennai airport, and everything that he predicted has happened, including the flooding and the floating and the planes turning into boats. In 1997, along with Arthur Pereira, ESG worked to try and stop the Mangalore airport from expanding. And we took the challenge all the way to the Supreme Court and also to the International Civil Aviation Organization. And our perception was based on risks, not merely environment, not merely social justice, but also technical risks. And we described what we thought can happen if you actually go ahead and build an airport on a top of a cliff in a heavy rainfall zone, where there was absolutely no safety area possible at all. There's no way to accommodate any risk, human or accidental and so on. Tragically, in 2010, Airbus crashed, unfortunately, exactly the way we predicted 13 years before that crash. We had written in the Supreme Court case that this is, if you neglect this aspect, this is likely to happen. Now, we didn't take any joy in writing that because we don't want anyone hurt. But what shocked us was we had actually even predicted that the plane would crash down the hillside, and probably if the train crossed, because the Konkan Railway is there, 1,000 more people would have died. The train had just passed 5 minutes before the air crash. Now, the reason that question has come up and why, you can take that example to what happened in Assam, to what happened with LG Polymers, what happened with the blowouts in the thermal power plants in Neyveli, and 10 people died in Gujarat, and this is all in the last 1 month. And then this is a country which has if you put all the industrial disasters together, no other country will come close to us. We are like so high up there. I mean, Chernobyl apart, Fukushima apart, if you put all the industrial disasters together, India will rank high. And that is because I think we have built a regulatory culture based on an acute dependence on an executive which is completely allowed to be intransparent, encouraged to be intransparent, and whether the Congress was ruling or BJP was ruling, there is no distinction in their faith in what, as Surit put it rightly, this whole idea of development, right? So, and I've seen judges, for instance, physically demonstrating this balance of development versus environment. There is no balance here, as the pandemic has. To even think that you can balance it is an hubristic statement. So I think we have to realize that when the world has shut down because of a virus, which is probably one of the most, it's not even a proper organism. It's a part of what can become eventually living. If that can derail our economy, if we can't take that up and it's not that we didn't predict this would happen. If you go back to the 2008 disaster management guidelines on biological disasters, somebody sat down and did some pretty good work and actually wrote it down in the guidelines on how not to build cities, how not to build densely crowded villages, so that if there is an epidemic, that it cannot reach the stage of a pandemic is part of human intelligence. We have the intelligence. The reason why that intelligence doesn't transform into what we now see, this disastrous law, is simply because we have become accommodative of a political culture and a culture of dependence on faith-based decision making. And I'm not saying you should be totally rational. Sometimes there are certain areas which are sacred and you shall not touch it. And not because you can comprehend what is sacred, because nobody should, because then it won't be sacred, but it's also because you have to have a sense of sacred. Something which is beyond comprehension of the humankind is a certain type of value which is essential so that we do not make disastrous decisions. Sometimes the precautionary principle is built on that we don't know enough, that we should always be in a learning process, that we should never damage the chances of future generations, and which is what we are exactly doing with this notification. This notification is about extracting for now. It is to justify the extraction for now. It is to justify the politics of now. This is not a notification which is written to manage the environment. This is a notification written to manage politics. So if we can get that idea in our head and wrap our heads around it, I think we are making headway.
Thank you. I have another question, and this also comes with a suggestion. So this is Mr. Joseph. He has 2 points, and the question is that the reduced hearing time is not justified, particularly when you look at project affected populations, and that they must be given an equal right to work out an EIA apart from the proposer, that there should be an independent EIA that is developed, and funding should be available from an independent environmental impact assessment authority with judicial powers like the Green Tribunal. So that's the first point, that shouldn't the affected parties population be able to put out an EIA on their own, one. Two, which is regulated by an EIA authority, and two, that the ecological footprint and vulnerability change with time as projects proceed, and maps to this effect must be available to the public so that they know which are the societies that are affected. So these 2 points, I just put it across to both of you, please. Mr. Saldania?
No, Surit goes because he's gone into the details of EIA, so it's better.
Right. Surit,
I would sort of certainly agree with him that, as you said, it's not, it's as much a question as it is also a suggestion. And I think as a suggestion, it's a very good suggestion, in that the entire sort of process of EIA can't be one-sided. You can't simply have the project proponent propose something, submit a report, and then have it cleared by these committees that are set up through these notifications. But I think it's also what Leo mentioned earlier during his talk, which is that we really need, I think, a substantive law on this. This is not something that can really be done through a notification. And this is what happens when we do things through a notification. We need a substantive, obviously there'll be certain things within that law which will need to sort of percolate through and which will have to come through the executive. But there needs to be a much more substantive law which is legislated on how an EIA will be done and what sort of role an EIA is going to play in sort of giving clearances for projects that might, but look, again, I also think that at some point we need to think more critically about this entire idea of an EIA. And because these EIAs seem to be some sort of Western model where the entire way in which it is structured is to ensure that projects are cleared. So maybe it's time at some level, and I don't know, maybe Leo can answer this, and I think he's addressed some of this through his writings, which is to kind of think of a completely different kind of a mechanism to deal with these issues. Not simply to think of it as an issue where you're interested in developing something and therefore you'll go to the government and get a clearance from it saying that there are no environmental issues. This is something that goes far deeper. And he's certainly right in that I think every kind of bit of information needs to be made available to the public. This is not something that necessarily has to come through only an RTI. And this is a big problem, right? As in the sense that if you're going to say that the government won't on its own put out information and won't give a project as much wide publicity as it demands, but people who are interested must file RTI applications and then thereafter seek this information, that's a problem. I think all of this information needs to be made as widely available as possible to people who are likely to be affected by these project communities that are likely to be affected by it. And again, I don't want to use the word stakeholders, but people, but if you can do that, and I think the public hearing aspect of it is the one that really needs to be strengthened. Ultimately, it's the people that need to be heard. And this is and look, there's also a big link, and this is not directly related to this question. There's also a big link between the conduct of EIAs and sort of the clearances that are given to projects and the entire manner in which land is acquired, right? And for a long time, you had this colonial era 1894 Land Acquisition Act, which was a complete sort of colossal monstrosity, really. It deeply impinged rights. But you then had this 2013 Act, which was enacted by the UPA government right towards the fag end of its term. And the 2013 Act is far from perfect, but at least it does bring in some of these elements into it in the sense of the idea of consent. If something is meant to be for for say the construction of a private hospital or a private educational institution, the government is acquiring land for those purposes, then the consent, at least consent of 80% of the landowners, is made mandatory. The idea of an EIA has been written into that law. Again, a social impact assessment has been written into the act. So the entire sort of this larger conception of environmental clearances, I think, is linked to acquisition of land in many ways, and we need to think critically on those lines as well. And there's been efforts, again, to dilute the Land Acquisition Act, this 2013 Right to Fair Compensation and Transparency Act. An ordinance was brought out, which was ultimately lapsed, but I'm sure that's another area which the government will try and amend again, because it's all of this is in this sort of idea of ease of doing business and improving our World Bank ranking on this ease of doing business. And to that end, you dilute labor laws, you dilute environmental laws, you dilute acquisition laws, and so forth. So I think we need to sort of see how all of this is sort of larger linked to the larger structures.
Yeah. If I can just add to that, and I'll just share my screen because Surit raised that concern, and I also see some questions coming up of whether EIA notification or EIA hacked. Look at what the Constitution says, and I'm just going to share a page. It's here. Okay, if you can read it, this is the Committee for District Planning. In 1992, the Constitution was amended twice, the 73rd and 74th Amendments. 73rd brought in the Panchayat Raj system across the country because some states already had it, and 74th brought the, basically it gave constitutional recognition to the local governments, rural and urban. Now, one of the core features of this is not just the fact that ward committees were required for larger cities. I've always asked, why not smaller cities, right? If panchayats can have panchayats and gram sabhas, why when you become urban, suddenly you lose the idea of representation? Now, representation is core to democracy. Now, if democratic planning has to work, you have to create systems to make it work. You cannot just leave a gap. And the 74th Amendment left a gap that cities less than 3 lakh should not have ward committees, and only those who are more than 3 lakhs will have ward committees. Now, that is not been rectified. I don't think this government will rectify it, but still look at what, at the Narasimha Rao government level, the Committee for District Planning actually wanted matters of common interest between panchayats and municipalities, including spatial planning, sharing of water and other physical resources and natural resources, integrated development of infrastructure and environmental conservation. Extent and type of resources available, whether financial or otherwise. Consult institutions and organizations as may be specified. And this was a representative body which was instituted as a constitutional body. Now, EIA notification is created by some babu sitting in Delhi. Most of them don't even understand India. They probably don't even understand Delhi. They probably don't even understand Paryavaran Bhavan. But they're sitting there in a seat of power and they're deciding our fate. Now, I think this should make us really very angry. And the fact that from 2006 to 2020, we have waited, and I don't know if you remember, in 2015, there was an environmental law, something comprehensive. Forget the thing it was called. I mean, let me show this. We, in fact, wrote to that. It was the Draft Environmental Laws Amendment Bill. This was withdrawn. If you go back to 2005, there was a Self-Certification Act as a private member bill, self-certification bill, which was promoted by a BJP member at that time. Thankfully, it never came to Parliament. But what is really happening now is actually self-certification. This is planned out and kept in 2005 and brought out and redone as a new law, and that too a subordinate law. So I really think that one of the core arguments we should have is we must assert the constitutionalism in terms of planning. Any planning, it has to be ground up, it has to be representative, it has to have a parliamentary character, and babus should not decide our fate. And I don't want to put it down that way, but they're behaving that way. And I think sometimes you have to share your anger in a constructive manner so that some transformation takes place. We can't just be, limp and, polite and, politically correct about it, because people are dying. People are suffering. Massive tracts of forest land is being destroyed. What is left to save if we just keep quiet and say we are going to be polite about it? I'm not saying we should be aggressive and impolite, but we must be angry and we must stop this madness. This is insanity.
Yeah, thank you. There's an interesting set of comments and questions that are raised on a certain aspect. And there's an interesting question as well related to this. So I'll post the question and then club the other questions along with this. So one Mr. Suhas Kolekar has said that Rohit Prajapati of Paryavaran Suraksha Samiti won a case against a chemical company in Ankaleshwar that was given post facto clearance, and the court ordered this as illegal. So his question is, can this case, the outcome of this case, be used in this particular context of the new EIA notification? And the several questions that I've received on this related to this point is there a legal option at this stage to go to court against the notification, the draft notification? Request both the speakers to respond to this, please.
Yeah, I mean, if I can just answer the second question first, which is that is there a legal recourse? This is not the time to go to court. And if the draft notification turns into a notification which ultimately sort of is notified, then obviously you can challenge it in court. But I also think that sometimes we kind of take this idea of like knocking on the court's door as sort of as a given, as some sort of panacea to all our problems, and sometimes and it often isn't. And because if you look at, although as I mentioned during my talk, the courts have been sort of playing or at least did play at one point of time, a critical role in molding and shaping environmental jurisprudence in our country and kind of reading into Article 21 all of these rights, etc. But if you look at other areas, and not just other areas, I mean the areas even on environmental jurisprudence and in terms of how the courts have dealt with this, you don't often see these sort of rights fructifying into remedies at all. I mean, it's all well to say that this abstract idea of Article 21 includes within it this right to a clean air and a healthy environment. But you don't actually see courts striking down projects or like coming down heavily on actions that have been sort of that have violated or that have impinged on an EC or that have failed to obtain an EC, etc. Now, there are, of course, as the other commenter has mentioned, there are instances where the court has frowned upon this idea of an ex post facto environmental clearance. One judgment is this judgment of the Supreme Court in Alembic Pharmaceuticals, which is the, I think, judgment that he sort of makes mention which is this Rohit Prajapati's case, where the court did say that this entire idea of a post facto environmental clearance is sort of anathema to the very idea of having an EIA. But that is under the old regime, right? Under the existing regime. If that regime is toppled by this 2020 notification, which explicitly permits it, then it would become fine. Unless the court strikes down the clause in the notification itself, which allows for ex post facto clearances. Now, I'll just to conclude very quickly on these 2 points. Now, mounting a legal challenge to this obviously would involve a sort of articulation of this right to life and personal liberty, right? Now, if this notification, if this draft notification turns into an actual notification, then obviously you have the option of going to either one of the high courts or to the Supreme Court and saying that this right to life and personal liberty under Article 21 is violated by this notification. But there's also this argument that might be made that having some notification is better than perhaps no notification, because then for a long time in India, we had no notification, right? Like, I mean, until the 1994 EIAs came in, draft notification came in, you didn't have this very idea of having environmental clearance, except for certain specific, like, as I said, like certain specific projects which needed it. But by and large, you didn't have this very idea. So is it possible at all to kind of challenge a notification of this kind as violating a substantive right? That's one hurdle that needs to be crossed. I think it's a hurdle that can be crossed if the court were to actually look at this in a pragmatic and in a sense in which justice really demands. But yeah, I mean, you can challenge this draft once it actually turns into a notification.
Mr. Leo Saldana, would you want to respond to that question?
I think Surit has made excellent points. I just want to add that there was a recent development in 2018. If people will recall that Harshvardhan was at that time the environment minister, and he wanted to push the draft forest policy, overturning the 1988 forest policy. 1988 forest policy was accommodating of many, many, many rights. It was not perfect, but it could be improved. The 2018 policy wanted to, in simple terms, privatize forest management and also privatize forests and also divert a large chunk of India's land to all sorts of ITCs and other, people who have lots of money and who want to kind of claim that that is going to be their gift to the world by just planting monocultures. We challenged it, and it went to the Parliamentary Standing Committee. At that time, Mr. Anand Sharma was the chairperson. Mr. Jairam Ramesh was a member of Parliament, also assisted in bringing up that issue. But the important thing is this: when the Parliamentary Standing Committee, which is a bipartisan committee, there are some 20-25 members from all parties, they actually said, you have a policy, which is not even a notification, it is not enforceable, right? You have a policy which is being drafted by the Ministry of Environment and Forests without any consultation with the Ministry of Tribal Affairs. And if you go to the Forest Rights Act of 2006, it is very clear in that act that anything that impinges on the rights, fundamental rights, and any rights relating to forests, people, tribals, cannot at all be legislated by the Ministry of Environment alone. In fact, they also, I brought it up before the committee, the business rules of 1961, I think it's called Transaction of Business Rules, basically states if there is a subject which has multiple ministries attending to it, then there has to be a nodal ministry appointed. And in that, the Ministry of Tribal Affairs was appointed nodal ministry in relation to anything relating to tribal rights or forests. So therefore, the forest policy of 2018, the ministry was instructed to go back and rework and come back after consulting with the with the Ministry of Tribal Affairs. Now, I also want to ask Suvrit, isn't this a constitutional problem? That the Constitution envisages evolution of law in terms of an harmonious interpretation of law across ministries, and no one ministry can arrogate to itself the promotion of a notification, which is a babudom. These are babu sitting and constantly, just look at this book. Even Supreme Court judges couldn't understand it. You think anyone else can actually wrap their head around their language? They write one line, by effect of this order, the earlier order is withdrawn. Now you try to go trace the earlier order, there will be another circular saying the earlier order is withdrawn. This is a maze they deliberately create because only businesses who have tons of money have the time to go and, they will hire some lawyers, not Suvrit definitely, but some other lawyers, and they do that work. Now, that is why I think it is a constitutional moment for us. we must insist that this is the time we stop the government, we stop the nonsense that is going on in the name of environment. Utter nonsense. It is insanity, right? If you allow them this time, in 5 years' time, you'll have a compendium which is 6,000 pages. And believe me, nobody will understand, even the courts won't be able to understand it. And that is the state of chaos and confusion they want, so that those with resources can move forward and those who are disempowered will simply be left, right? So I think that is where we are.
So in connection with what you were just talking about, there's this question from Tara who says, so what about the forest communities, the Adivasis, and their culture and spiritual beliefs, which is so intrinsic to their locale, the forests? This sort of a notification, where do they stand with respect to this sort of a notification, the new draft notification?
So let's go ahead.
I mean, I don't even think it sort of really takes into account
essence of.
Yeah, it's
as a stakeholder. I mean, using that word.
No, I mean, it simply sort of disregards a number of these things. It just sort of treats this, as I said, as some sort of problem, as a hurdle that needs to somehow be crossed, and that they find that, remarkably, they find that this 2006 notification, which is filled with all kinds of sort of problems and difficulties, is somehow still, providing them with barriers which they're not able to cross. So which then really ought to show us how far this sort of rabbit hole that we're kind of entering. Because, if the 2006 notification is seen as thwarting business, then I'm not sure what really a good or a sort of a working notification is supposed to do. Because the 2020 notification, as I said, it's simply, you can't kind of treat this as something that's been done in furtherance of the Environmental Protection Act at all. The Environmental Protection Act enjoins the state to take steps to sort of promote and preserve the environment. But it's obviously something in doing that, it needs to consider all of these other factors. Whether it's natural heritage and culture, or rights of Adivasis, rights of other tribes, rights of different communities. It's something that any notification, which if it is meant to work properly in a manner that is meant to secure justice, is supposed to take into account all of these things. Which is why I think that we need to sort of also see these things as a larger, we should never see, while the environment has to be seen as something which is a value unto itself, it needs to be seen as in terms of how it relates to all of the way we lead our lives, right? The way different communities lead our lives. And only when we do that can we really sort of take us onto a path where we can secure justice for everybody. Because the Constitution, again, it speaks about right to equality. And I just want to make this couple of points in terms of how a potential challenge to this notification might be made. One is, obviously, there are rights of these communities that are being violated by a notification of this kind. But the Constitution, apart from, and we have this tendency to see environmental rights as flowing only from Article 21, which is also a problem, because we have to see these values as sort of mingling with each other. And Dr. Ambedkar spoke about this with great passion during the making of the Constitution, which is these ideas of equality, liberty, and fraternity forming a sort of trinity, right? So we have to look at environmental rights within this larger prism of equality, liberty, and fraternity. And only when we do that will we, I think, really move forward. Because a notification of this kind is simply arbitrary. It treats equals unequally, because it simply disregards the rights of these various communities. And it also kind of demolishes this conception of fraternity and of us living together as equal beings. So I think we need to kind of see all of this as values that are part of a node of sort of values that ultimately lead to this sort of unitary vision of constitutionalism and a unitary vision of a constitutional morality. And the one other thing, and I think there's one question from Mr. Devasahayam on this in the chat.
Section 3.1, yes. Section 3.1 of the Environmental Protection Act.
That's, I think, one of the core challenges that will be made. Apart from the fact that this notification is ultra vires the Constitution, it's also ultra vires the Act itself. Because the Act speaks 3.1 says that the central government will have the power to take all measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling, and abating environmental pollution. This certainly doesn't do that. So,
In fact, you can even argue that this is actually promoting the business first approach, which is undermining the environmental conservation requirement of Section 3.
Yeah, there's one recurring question that's again there. So, what would you suggest for people who are concerned about this act? What's the way forward? Does sending emails or their concerns to the Ministry of MOEF and CC, will it help withdraw the notification? What can environmental groups, so what would you suggest as a way forward in the run up to the August 12th deadline that we have?
Okay, there are a lot of movements and a lot of efforts that are parallelly going on. In fact, we have two judgments already, one from Delhi High Court and one from the 11th August deadline was from Delhi High Court, which also went on to say it has to be translated. Right now, how do you operationalize the translation into, I guess the country has capacity to translate, not Google Translate, but real translation. And then make sure it reaches. The whole approach is that it actually goes to every Gram Sabha, every ward level, and people engage with it. People may be flummoxed by the kind of jargon that is written and the kind of complex language, but at least there is that document in a language they can read. Understanding is the next part, then interpretation, and then engagement, and then finally, trying to put out your point of view. Now, how do you do that before 11th of August? I don't know if it's possible. But the court has thrown a challenge. The day before yesterday, in another case, the High Court of Karnataka said that, more or less same things, but they did not want to put a deadline, extend the deadline, because their sense was, if you want to formulate law which affects people, then people must shape the law. That's what Justice Oka basically said. Where are the people in this? People are locked down, right? So how can you make people who are under lockdown come out? I mean, when you come out, you're arrested. If you come together, 4 or plus people, unless we do it this way, now I don't know how you can sit down and work a law through this mechanism. Parliament has been shut down. Just yesterday, Jairam Ramesh, who is the chairperson of the, the Parliamentary Standing Committee on Environment and Forest, said they are not being allowed to meet. So, I mean, this is a country now which Narendra Modi with his bunch of bureaucrats will run. I don't see the constitution written in a way that he can actually manage this country this way. So I think that's why I said it's a very, very serious constitutional moment. This is an executive trying to attack the parliamentary system. It is an executive attacking the local governments. It is an executive attacking the state governments. Now, this is when the true character of our chief ministers, regardless of which party they are, should be exhibited. They should stand up and say, enough is enough. This is a federal governance system. We didn't just get elected to just keel over and fall from our chairs. We are going to sit firm. We are going to fight back. This is not a notification about environment. That's why I keep saying this is a political instrument. This is to prize open and justify a lot of illegalities, the post facto clearance being one part of it. In any project that comes, I mean, this is a book that Jairam Ramesh wrote after he was, he finished his term as a minister, not just environment minister, but also as rural development minister, in which he admits for the first time, 97% of the projects which come with their EIA documents are fraudulent. Is anyone gone to prison on that? Not one, right? I don't know. Last I remember is one chief conservator of forest was imprisoned in Maharashtra for something fraudulent that he did in terms of the report he presented about a forest diversion. Apart from that, I have not heard of anyone. If that had happened systematically, that is why this is based on criminal jurisprudence. And the attack here is not just about diluting the provisions, it is also to adjust our environmental laws to the Western investors who are totally afraid of the fact that our laws are based on criminal jurisprudence. Any violation of an environmental law is a violation of, it's a crime. It's not just a civil offense. Now, which is why 10 people got arrested in LG Polymers. And you need that. In a country so populated, in a country in which a lot of people are struggling to make ends meet, in a country where 80% of the wealth is in less than 1% of the population, you need Article 39 of the Constitution working now. That has to be the direction in which the country moves, regardless of which party is in power, right? So that is the idea of the constitution, and the constitution is to grow towards that challenge. And here we are sacrificing the constitution for a mere subordinate law, which thoughtlessly Prakash Javadekar just put it out one day, or thoughtfully put it out one day before the lockdown. Lockdown is announced on 24th. Obviously, he knew that the lockdown is coming. He basically wanted to rush it through, because there are people like us who are, capable of organizing more people. So how do we take it forward? We must organize. We must agitate. We must educate. Ambedkar said it. We must do it. There is no two things about it. And there are coalitions which are doing it. There are groups doing it. But one thing I think we should all agree on is we must accept. We are not going to accept a notification anymore. It has to be, as Surit said, a substantive law. It cannot be amended just on the whim and fancy of which project is pushing it, because that's exactly why there are like 150 amendments to this 2006 version. But it has to be substantive, so that there is that difficulty of going to Parliament and trying to wring out an amendment. If that difficulty is not there, we are finished.
So I think that's an important point that we are all converging on, and which is really that it's time to move away from an EIA notification to a law that replaces this. And that's been a recurring question in the forum today. I have another interesting question that's just come up from our live streaming page, and that is this person Ravichandra Tawag from Sun TV. So he's gone a little philosophical. He says, as expounded by Yuval Noah Hariri, for last several centuries, environmental destruction has been the hallmark of Homo sapiens. How do we address this issue? So I think it's a little philosophical note, but it's a call to think personally, but think globally on this matter.
The answer is very simple. Just ask Corona, no? It has taught us a lot of lessons if you are willing to listen and willing to learn from them. Yes, I think broadly the kind of questions that we've been having, I categorize them and address them to you. The speakers, if there are any closing comments at this stage, please, I request you to speak now. And then finally, I request Tara Murli to summarize and close this session, please. Surit and
No, not really. I think, we've covered quite a bit of.
Yeah. I'll just share my screen one more time. Sorry,
please.
I'm sharing the screen too much too often. And that is mainly to show you this page. I'm sorry, just a minute. This is also by Intact, right? So it is not just about, Intact has been the conscience keeper about heritage. I don't know if the story makes any sense to all of you, but in 2005, Mr. Sridharan, when he was Metro chief, he goes to Dr. Manmohan Singh and he says, all these environmentalists are blocking metro projects and asking too many inconvenient questions. After all, we are going to clean up the environment, and so please exempt us from the EIA notification. And so in the draft 2005 notification, metro projects were required to go through environmental impact assessments. And because Sridharan had an absolute sway over the thinking of the central government, it was dropped. So 2006 notification did not have metro requiring, going through public hearing and so on. Now, this is what I'm showing is the Sacred Grove of All Saints Church in Bangalore, which has been now fighting for 420 days, nothing to do with the IPC. And they're trying to protect it from the metro ruining all of this. This is one of the oldest churches in Bangalore, right? And my point is this: how does metro actually come to think of running a railway station through this church? You see, there has to be a sense of aesthetic. There has to be a sense of grandeur, of the old, of the archaeological, of the beauty of a grove like this. Trees there are 200 years old. And you should see the language with which the metro justifies it. We can always replace these trees, we can transplant these trees and so on. And then the matter ends up in High Court. Now, why I'm sharing this page here is because we are absolutely in a situation where thousands of such buildings of great character, of great and rich cultural history will be ruined by this notification, because this notification just doesn't have imagination. It is written by an engineer who basically is not put on horse blinds and followed the diktat from whoever is holding the money. Let's be clear about the politics behind this notification and make that effort to, whichever government is in power, they can always yield to people's power. If they don't, then they have to go.
So that's an interesting point where you've brought the environment and heritage conservation together. And my thought is on the amendment to the MSR Act, which was passed by the Lok Sabha, but is still not, has not been passed by the Rajya Sabha, which is about the protected, prohibited, and regulated areas around a historic monument of national importance can be compromised if it's a project of public importance. If it's an infrastructure project of public importance. So that's the amendment that's actually in the MSR Act, in the amendment to the MSR Act, which has been passed by the Parliament. So there is a common thread in the new notification of the EIA and this. So I'll leave it there and thank both the speakers and request Tara to speak, Tara Murli to speak, sum up the discussion we've had. Thank you.
Thank you.
Thank you, Leo and Sufrit, for a very comprehensive presentation. And I also realized that the topic is not familiar to people who are neither lawyers nor environmental activists. Many of us are, in other fields. And speaking for Sujata, Arun, and myself, let me say we are mere architects. But we understand the seriousness and the consequences of this notification. Just to take it in our own profession, we've been fighting for city planning to bring in the 74th Amendment into planning, so that the city is not viewed, the metropolis is not viewed with a one size fits all. And we feel that specificity and locale and the importance of communities is very, it needs to be critically analyzed and included in our planning. The main thing is, what is heritage and what is culture is what we are actually, and how it will be impacted by this notification is what we are talking about. I'm just going to go back to city planning and give a little example. When, if there is a temple and there are a group of people who, participate in the functions of the temple, and this includes and this includes includes people who are flower sellers, who are, and one of the things that we see is that for temple festivals, every day a different sort of garlands were made. They were made out of different flowers. They were made out of different, to enhance the idol that would go outside. Now, when you break up these communities, then what happens when, land planning breaks up communities? No longer is this knowledge passed on. So we've lost something intangible, which we can't even, before we even know what it is. It's continuity which gives this particular, which will help to foster it. I take the same angle for forest dwellers. They look at forests as places of spiritual, what should I say, spirituality. And if you destroy a forest for its resources, what you're destroying is also people and communities. And what are we all working for? And what do we want to get if we don't have that realization? I think that is the reason why this whole concept of what this notification does to us as people for culture, it is it needs to go beyond. I think it needs to go beyond just, resources, projects, the language of management, so to say. And I think we need to have a more holistic approach of what what its impact will be, and how it makes us less sort of uh, less human. And as Leo said, in these corona times, I think many of us have actually have a better understanding of what it means to come together. I think we should build on that and then try and see what steps we can take to see that our environment, and through that our natural and cultural and intangible heritage is not destroyed. Thank you.
On that wonderful note,
Thank you, Arun,
thank you. We
for
should
coordinating this, and I hope all our listeners enjoyed and learned as I did from the talk.
absolutely. I think it was a fantastic experience to hear from our two of our speakers. Uh, thanks to Intact for organizing this. A very
Thank
good
you all.
evening to everyone. Thank you.